Thanks for joining us. It's great to see so many people here. I'm Simon Stern, president of LCH, and it's my pleasure to start this new Zoom series, which we hope to be offering monthly. And this first episode is devoted to a forthcoming issue of the journal Law, Culture, and Humanities, focused on legality and affect, and edited by Birte and Wibke Schniedermann. They are Birte teaches American literature and cultural studies in the English department at JLU, and where she's been working since October 2009. Wibke is a postdoc in the Literary Studies department at Ghent. She received her PhD in American Studies from Goethe University for a dissertation on masculine domination in Henry James's novels, and her current research explores connections between place and homelessness in US literature and culture. And I'm going to leave it to the two of them to introduce our three speakers. Thanks so much to both of you for doing this.
Well, right back at you, Simon.
I'm super thrilled to be here, but Wibke is going to take over the introductions, but great to see everyone.
Yes, I can only second that. Thanks everyone for being here, and to Simon for organizing this. We're very excited to have the chance to kick off this new series of events. And I have the pleasure to moderate today's roundtable. Like Simon said, Birte and I are the editors of a special issue of Law, Culture, and the Humanities, a forthcoming special issue that is already available online, and it addresses a current debate in the field of law and literature, namely the recent critical invention by one of our colleagues and mentors, Greta Olsen, who is, of course, also here. So when Greta's book From Law and Literature to Legality and Affect was published, Birte and I, of course, together with all other colleagues, knew that it was going to break new ground for the field of law and literature. And we wanted to make sure to do our part in making sure that Greta's call was heard, Greta's call to take affect seriously as something that is deeply enmeshed with the legal. So the special issue explores the concept of legality, understood as Greta does as effectively felt law. And it does so in different cultural, political, and legal discourses. Today, we are very happy to have three of the contributors here, the contributors to the special issue. There were supposed to be four, but unfortunately, Laura Borchert cannot join us today. Her critical analysis of anti-transgender bills that were recently passed in the US would have really been a very unique perspective here, as it puts this new understanding of legality to the test, kind of, by asking how it can be made useful for LGBTQIA rights activism, and we will miss her today. We are, however, all the happier that three outstanding scholars are with us here, and they will each give us a brief overview of their contribution to the special issue, introduce their case studies, argument, and we will have a discussion among the panelists, and then open everything to questions from the audience as well. So we're hoping for a lively discussion here. I will introduce the speakers. Oh, Birte, you wanted to add something?
Let me jump in and say that Simon is here too. We actually have four contributors present.
Oh, that's true.
I'm
so sorry.
Presenting in his own series, okay? He's the boss of the whole thing. Okay, let me just mention that. But go ahead, Wibke.
Thank you. Please, I will rely on you to continue doing that when I forget something very obvious. Please keep jumping in. So I think I will introduce each speaker before they actually go. Our first speaker today is Gerlov van Engelenhoven. He's assistant professor at the Leiden University Center for the Arts and Society and the author of Post-Colonial Memory, Meaningful Voices, Meaningful Silences. He specializes in post-colonial memory studies and is currently running a 4-year Vennie research project funded by the Dutch National Research Council, entitled Listening to Silence, Silence as Empowerment in Contemporary Dutch Post-Colonial Memory. In his contribution to the special issue, Gerlov explores how conflicting legalities inform current controversies around post-colonial memory in the Netherlands. Gerlov, the floor is yours.
Thank you so much. I hope the sound is okay. I apologize for the blurring of the background. I'm in the children's room, so if I wouldn't blur the background, it would be very distracting. There would be lots of childish things abound. So yeah, it's 5 p.m. here in the Netherlands. It's dinner time for my kids. I hope they will not enter the room as we speak, but you can never be too certain of such things. So without further ado, thank you so much for having me. I'm very honored to be part of the special issue and to be part of this event today. And without further ado, I'll just jump right into it, I guess. My article is about a colonial statue of a colonizer that is placed on a public square in the Dutch town of Horen. It's a statue of Jan Pieterszoon Koen, a famous Dutch colonizer, remembered as a Dutch national hero because of the fact that he kickstarted the Golden Age, as many Dutch people still call the 17th century, the Golden Age, because it was a time in which the Dutch were a prominent colonial power. And Koen's role in kickstarting the Golden Age is that he established the Dutch trade monopoly on spices, so the spice monopoly in current-day Indonesia. That made the Netherlands rich and well-faring, hence his status as a national hero, and hence his statue in his birthplace of Horen. But then, of course, there is the shadow side to this history where he is remembered as a hero, and the shadow side has to do with the fact that the way in which he pursued this monopoly was particularly violent. He entered the Banda Islands in current-day Indonesia in the year of 1621 with a small army. There were spice plantations there that he wanted to take control of, and the place was inhabited by around 15,000 Bandanese people, of which he murdered 14,000 in a matter of days, and the surviving 1,000 people were enslaved. And then the territory was repopulated by more enslaved people from elsewhere in the empire, so to speak. And then they were put to work on the plantations. He also created scarcity by burning down a majority of the plantations. So it is a form of ecocide connected to a form of genocide. So this is the violent side to his history, and him as a genocide committer is one of the common ways in which Dutch society remembers him. That is a counter memory of the one where he's remembered as a national hero. And obviously, this is a conflict in Dutch society that is about colonial history as such, but it is almost conveniently materialized into the issue of his statue that stands in a prominent place in the Netherlands. And in current day, let's say in the Dutch national news, the way in which this issue is framed is there's a tendency to frame it as if this is a new kind of like a woke development in society, especially in post-George Floyd society since 2020, when suddenly people wanted colonial statues to be removed all over the world. And that is factually untrue. As long as this statue exists, there has been controversy about it. Even in the late 19th century, when the statue was only still an initiative, it was actually already criticized. There were prominent historians at the time in the late 19th century going on the record criticizing the initiative, saying that it would be perverse to honor a mass murderer with a statue. So the controversy is as old as the statue is. And then, but the first link that I make to Greta Olsen's work on legality and affect is that it has to do with her concept of rechtsgevoel. So I quote from Olsen. She defines legality as, quote, the totality of what people perceived to be binding norms. Legality then includes individuals and groups' rechtsgefühle, that is, people's impassioned feelings about their legal environments. And then according to Olsen, people's affective relationships to the law are to great extent shaped through cultural expressions of the legal, which include fictional representations of law in film and in television, but it also includes images and sculptures relating to law, as well as in courtrooms and also monuments. So to me, end quote, to me, Koen's statue is an example of a cultural expression of legality, because it invites an affective relationship to the colonial past. So it is not only kind of material icon that resembles or something that happened in the past, but it is also an object in public space that makes people feel something about that past. So it contributes to the affective dimension of memory, which in memory studies is also, the affect is very important in memory studies as well. The issue with conflicts over, in this case, post-colonial memory, is often that different affects are kind of triggered and clash with each other. And in this case, concretely, one affective relationship to Koen's history is one of pride. So people can feel pride and take pride in their colonial past through glorifying gestures such as creating a statue to which you literally have to look up. So Koen is then framed as a man that you look up to, an example, basically, a national hero, an entrepreneur, a brilliant merchant and strategist. And then the opposite kind of rechtsgefühl that is triggered by the same object is that of the opposite, anger, kind of frustration, and taking the statue as an insult, but also taking the statue as a frustrating kind of proof of the fact that the Dutch state until today refuses to acknowledge the horrifying results of colonialism that's still kind of that we still encounter in contemporary society. So it's also this feeling that the colonial past is not a closed chapter in history that we look back to and say, oh, those were more cruel times. For instance, the killing that Koen committed on the Banda Islands, we would now take offense, but at the time this was quite normal. That would be an approach to understanding the colonial past as a closed chapter. But then the ones who take offense with the statue would say, actually, Koen is not a product of his time. Koen produced, helped produce his time. So the cruelty of Koen also partly set a standard that made it possible for colonialism to be pursued in this particular way. So to me, Greta's. Oh, sorry, I'm just using first names. I hope that's all right. It's what I'm used to. Greta's theory helps me understand why discussions about the statue often become so intense in society, because it's not so much reason-based, like it's not a rational discussion about how the history took place. It is very much an affect-laden discussion about how we should feel about this past, whether we should feel pride, whether we should feel guilt or embarrassment, whether we should feel as if we are part of the perpetrators, and then it really depends on who the we is in this affective relationship. So, and to make that really concrete, like I'm from a post-colonial background myself. My dad is Malaccan Indonesian. My mom is white Dutch, kind of, and born and raised in Hoorn. So my dad is Malaccan, and to him, the statue is what I just said. It's a kind of an insult, and it is just for him, it's a typical thing. Like he looks at the statue and he rolls his eyes and he says, "Yeah, of course, this is something that specific Dutch people become very adamant about, and they say it's the hands of our statues, etc." So to him, this is just one of the many obvious pieces of evidence to him that the Dutch state is in denial about the things that it has caused to people like my father or his family that were involuntary migrants from Indonesia in the direct aftermath of the independence war. My mom was born and raised in Hoorn, so the statue to her is something completely different. Affectively, it's something that she remembers fondly. It's a nostalgic feeling to her, and the statue is first and foremost a piece of art in public space. It has aesthetic value, and to her, it's frustrating if it gets politicized, as she would say. And I would say it was already political from the beginning, but that's, that we don't have to do the discussion that I have with my parents from time to time. We don't have to stage it here today, but you can imagine what goes on. So to her, it's a piece of art that gets politicized, and that's not a rational argument first. It's kind of an emotional argument first. It just thinks, why does everyone, take offense with this beautiful statue that reminds me of my youth? So that's one step in the argument in the article. And then I zoom in specifically on, there's a long history of protests against the statue, but the one that I always find most interesting and in a way funniest is the one that happened in 2011 when the statue literally fell off its pedestal in a kind of an instance of what I always call cosmic irony, because it wasn't toppled by protesters, as you might assume. It was actually an accident. So there was an annual fair always in the square where the statue is located, and after cleaning up the fair, just a crane truck smashed into it by accident, and just a Koen fell on his face, literally, just forward, and was damaged heavily. And it was just lying there for a few months. And the municipality was, making plans for its restoration. And in that time, a petition was published by protesters, and they framed the question of the statue also in a legalistic way. And I'm going to read from their petition now. I quote, the petition said, "We, the Dutch, who are host to the International Criminal Court in The Hague, ascertain that it would be pathetic for our country if the municipality of Hoorn honors genocide committer Jan Pieterszoon Koen by placing his fallen statue back on its pedestal." So they kind of created juxtaposition between two contradicting elements in what we could call the Dutch society's legal self-identity. Like they say at one time, the Dutch proudly host the ICC, which, among other aims, they have the aim to prosecute genocide committers. On the other hand, we, the Dutch, also honor genocide committers. So there's kind of a discrepancy here that at least is a form of hypocrisy. At most, it's just a real big problem that needs to be dealt with. For example, by not putting the statue that has already fallen after all, by not putting it back on its pedestal. And they had a very concrete suggestion for an alternative. They say, after renovating the statue, you could also place it in the Westfries Museum, which is a museum about the 17th century, which is located at the same square as the statue. So the moving cost would be minimal in a very Dutch pragmatic sense. They made the calculation, if you were going to have to spend a lot of money putting it back anyways, you might as well move it a few meters to the right and it would be in the museum. And then the entire context would be changed. So there's that. And then the way in which the municipality of Hoorn responded to this, to me, is always very interesting, because they did and did not listen at the same time to this suggestion and this kind of voicing of dissent. And they said, so they placed the statue back on its pedestal. And so in a way, they did not listen to the suggestion to not place it back on its pedestal, but then they updated the plaque. And the plaque, it would be too much to go into it now, but one of the things that were updated in the information offered with the statue is kind of like a disclaimer. So a sentence that reads, "Not everyone would agree that this man deserves a statue." So in a way that in the article, I do this in detail, but there's kind of a close reading of the way in which they neutralize the dissent by acknowledging it. So they kind of say, some people feel that this person does not deserve a statue. Some people feel like the statue is not without its controversies, basically. And there's a disclaimer at the end of the information in the statue. And to me, I flagged that in the article as a form of repressive tolerance, a term that I take from Herbert Marcuse. And repressive tolerance is when a position of power represses the opposition, paradoxically, by tolerating it. So by giving space, or by allowing the opposing kind of position in the official discourse, it is effectively neutralized, rather than, so instead of an empowering gesture, it's a repressive gesture. And that is always a confusing step, because it kind of creates a question mark for the simple assumption that speaking up is a first step towards empowerment. Because in these cases, when power responds to it strategically, being heard can be the end of the story rather than the beginning of the story. And the same happened when the other thing that the municipality did in response to the petition was they started a museum exhibition in 2012, which again was, for legality, this is interesting because it was presented as a court case. So it was an exhibition about Koen and his legacy called Koen, Hero or Perpetrator, or Koen, Famed or Reviled. You make the decision, and then actors played the roles of the judge and of the prosecutor. And then the visitors were the jury, and they were supposed to, after hearing the full story, good sides, bad sides, to make up their own mind about whether or not Koen is a hero. And again, in the article, I close read the entire exhibition to kind of see how it is skewed and kind of helps visitors make the decision that the statue is fine, as long as you contextualize it properly. And here again, this is to me again one of those moments of repressive tolerance by staging the disagreement on how to feel about the statue kind of as an art piece with a certain outcome. It is effectively neutralized, and I think this is more or less like yeah, where I can finish, because the article is basically an open question when it comes to this, because I feel there is the potential risk, and I would like to discuss this in the conversation afterwards, is that of course what positions of power have done strategically for a long time is frame their opposition as emotional, and to say like yeah, we have the right kind of perspective on things, and then there's people who feel that is wrong, and they become really emotional about these issues. And certainly that has been the case for decolonial activists, are often framed in Dutch media as emotional. And of course, the statue is just a statue. That would be the quasi-rational kind of approach to it. Some people become really emotional about the statue, and they want it to go, and that's their feelings speaking. So this is like, and I don't really, it's just a feeling. I don't really know what to do with it yet. I would love to hear Greta's thoughts on it later as well, because I feel that the acknowledgement that there is a plurality of feelings about justice in society can also be a really good way to neutralize that plurality and kind of like maintain the status quo if done by the wrong people, perhaps. So that's an open question to end my presentation with today. Thank you for listening. Looking forward to your comments and questions. Thank you.
Thank you, Gerlov. Wonderful. We'll move right on to the next presentation. Our next speaker is Jeanne Gakeer. She's Professor Emerita of Jurisprudence, Hermeneutical and Narrative Foundations at Rotterdam's Erasmus School of Law. She's the author, among many other publications, of Judging from Experience, Law, Praxis, Humanities. Her research focuses on interdisciplinary movements in legal theory and their relevance to legal practice, and her current projects specifically focus on legal narratology. Together with Greta Olsen, she is co-founder of the European Network for Law and Literature, and also the recipient of the J.B. White Award. Jeanne joined the Court of Appeal in The Hague in 2008 and was a senior justice in the court's criminal law section for 7 years, where she still serves as deputy justice. In her contribution to our special issue, Jeanne turns the attention to the ways in which affect can be instrumentalized in the courtroom, especially with regard to the theatrical and dramatic elements in legal performances. Jeanne, take it away.
Thank you. Thank you for inviting me to participate in this meeting, and thank you, Wibke, for introducing me in such a generous way. Now, in her book, Greta Olsen imagines that a certain justice in The Hague would chuckle, asking, what is one to do with the questions asked by scholarship on affect in actual legal practice? And that certain justice is yours truly. So in my article, I rose to debate thrown my way. As a judge, I encounter emotion and affect, and I always ask what the consequences could be for the people involved, which is also a normative moment, of course. However, where Greta Olsen speaks of legality as, and I quote, the totality of what people perceive to be binding norms, the definition that Gerlov also quoted. And when she argues that affective experience contribute to it, I am more critical. Affect may deceive the bodies that we are. The one individual may be affected differently from the other by the same event or object, as in the case of Gerlov's statue. What is more, law has its discursive and performative limits precisely because of its legality. And so in my article, I did two things. First of all, I turned to Spinoza, the man himself, because I perceive that affect studies often suffer from definitional varieties, which easily leads to confusion. After all, Spinoza's ethics dates from 1677, but when he is invoked today, I found that many analyses of affect build on secondary sources. And what is more, much depends on translation. Because what Spinoza calls affectus in the Ethics is usually rendered as emotion. That's the only translation you find. So adequately gauging the relevance for law of the secondary sources depends on the primary source employed. If you do not use the Latin original, you have to depend on the quality of the translation. Now, Spinoza differentiates between affectus as emotion and affectio as the modification of the body that is the result. So the bodily effect that comes with an emotion, such as the shivers or a literal gut feeling. And affectus, and that is a thing that many people seem to forget, also comprises what the human mind thinks of what modifies the human body, which is why I would urge affect theorists to consider empirical studies. I will come back to that in a couple of minutes. Secondly, I analyzed two jurisprudentially dramatic cases to highlight different forms of affect and point to culturally significant factors. I call them show trials because as a performance, they show and tell us something. They tell us something about what is brought before the court and how it is being read and given meaning by those in charge in the institution. So to me, the trial is also a normative mirror. And both cases I chose, I think, are interesting for the ethnography of the legal performance of sentencing that uncovers effective legalities or not. And both trials are also show trials in that they have had consequences beyond the courtroom and are to be understood within different historical, normative, and political frames. Now, the first trial I turn to in my article is that of Derek Chauvin, who put his knee on George Floyd's neck. Now, for reasons of time, suffice it to say that public outrage was enormous. So was the looting of shops that followed. And the legal procedure against Derek Chauvin was not an easy ride in terms of affect, but its legality was not questioned. And the trial was broadcast live. The prosecutor argued, and I quote, "He's not on trial for who he was. He's on trial for what he did," which is essentially, of course, the crux of most criminal law systems. It is a system that focuses on deeds, not on anything else. Yet, in his closing argument, the prosecutor rhetorically emphasized the 9 minutes and 29 seconds that Chauvin knelt on George Floyd. And he did so for 22 times. And he tried to elicit an effective response by asking the jury to imagine their first impulse on hearing about Floyd's death. And he said, and I quote, "This case is exactly what you thought when you saw the video. It's what you felt in your gut. It's what you now know in your heart." And so on April 20, 2021, Chauvin was found guilty of murder. And the verdict too was broadcast live with some 23 million people watching. So you can see the enormous impact. And my question would be, did the repeated images of the footage of George Floyd's death throes influence those who judged Derek Chauvin? Because research has shown that gruesome audio-visual materials affect people more than textual descriptions of the same event. That is to say, the medium co-constitutes the affect. And there is a connection between the level of gruesomeness the vividness of the footage, and the kind of emotion it triggers. Now, my second trial is far less famous or infamous. It's that of Dominic Ongwen, who was found guilty in 2021 by the ICC of 61 out of 70 counts, varying from crimes against humanity, including murder, torture, enslavement, forced marriage, to pillaging and rape. And he was sentenced to 25 years of imprisonment by the ICC. But the question the defense asked was he a perpetrator only, or was he also, or perhaps merely, a victim? Because at the age of 9, Ongwen had been kidnapped and abducted into the LRA, Joseph Kony's Lord's Resistance Army that opposed the Ugandan government. And he was not alone. There were approximately 15,000 child abductees. But he was one of the few who became a high commander. So what the defense claimed was that Ongwen had been a child when he was abducted, and that he was brainwashed, had been brainwashed for many, many years, and that this experience in the LRA had traumatized him, so that basically you could not think in terms of mens rea, and he could not be blamed for his acts. However, the ICC prosecutor, Fatou Bensouda, argued that Ongwen stood trial for what he did as an adult. And she recommended a sentence between 20 to 30 years of imprisonment. Now, something interesting happened in terms of legality, because the defense asked for a lenient sentence because Ongwen had admitted and had agreed to accept to undergo a specific ritual of what is called in Uganda the Ikoli traditional justice system, and that includes a ceremony called Mato Oput, which leads, when effective, to reconciliation if the defendant pays compensation to those who have suffered, and if he is willing to undergo a ritual of reconciliation, which will then prevent further revenge killings. Now, this is the very interesting point of the Ongwen trial in terms of effect and legality, because the court did not accept Mato Oput when they considered sentencing, because to them, and they focused on their own statute, the statute said we cannot have an incorporation of elements of local and or traditional justice. So the principle of legality of ICC precluded the use of Mato Oput as affecting a lower sentence. And in the end, the court held Ongwen fully responsible for what he had done and also for who he had become. And they did not accept any measures or aspects that would have led to a more lenient sentence. And I think that the George Floyd or the Derek Chauvin trial and the Dominic Ongwen trial both show that the emotional sides of a case, the affect at work, and the narrating or framing of those involved cannot easily be tied to a shared sense of law and justice and legality, I think. So that's for now. I look forward to any comments by Greta specifically, because I think she will disagree with my point of view. Thank you.
Thank you so much, Jeanne. Our third presenter today is Frans Willem Korsten. He's professor of literature, culture, and law at the Leiden University Center for the Arts and Society and professor of literature and society at the Erasmus School of Philosophy. His research focuses on the relation between literature, art, politics, justice, and law. It also focuses on a bunch of other things that I will not have time to mention today. He is the author, also among many other publications, of Art as an Interference, as an Interface of Law and Justice, Affirmation, Disturbance, Disruption, as well as Cultural Interactions, Conflict, and Cooperation. He currently takes part in a program entitled Playing Politics, Media Platforms Making Worlds, where he is looking at the ways in which populists and big corporations try to play with the judiciary and the rule of law. This is also the subject of his contribution to the special issue, in which he takes a closer look at the ludic and one might also say ludicrous legal strategies of three populist leaders from both sides of the Atlantic. Frans Willem, the floor is yours.
Thank you so much. And thank you for inviting me to kind of contribute to the conversation. I was very happy to participate in a special issue that honors Greta's work. And perhaps before I'm off with, let's say, more the content of the thing itself, some context. So it's part of a project that's called Playing Politics, as you mentioned, media platforms making worlds. Fascinating thing is we come together with scholars from different disciplines, philosophers, media scholars, different media scholars, literary scholars. We've been working together for 3 years now, and we still don't agree on how to define play, or how to define politics, or how to define making worlds. Which is also, let's say, part of the value of the project, that we kind of live in friction. But it's also important then to make clear what we mean with concepts. So in this project, I'm focusing on how, especially populists, but by now more and more corporations, which I think is something that has been underestimated in terms of how they play with law and the rule of law. So what do I mean if I say populists play with the rule of law or with the judiciary? That's actually more adequate. And here, let's say, my contribution to this project has constantly been to make a distinction between play and game. Because especially in game studies, people say that people play a game. Yes, that's the phrase, but conceptually speaking, that's not playing. Let's say, conceptually speaking, philosophically speaking, it is a form of play for sure. But let's say it doesn't accord well with what I define to be, philosophically speaking, the essence of play. So if I say populists playing in court, in a sense, one of the articles that I published together with the philosopher Frans Willem Korsten says Trump is not a politician and he's not playing. He is aware of the rules of the game. That's something else. And he is very much aware, and I think that's one of the perhaps more not things that are not highlighted enough in the project, is how to make worlds. Right, so when we discussed what is politics, politics is in the end, let's say, the attempt to make a world, to either continue a world or to open up, let's say, the possibility of an alternative world. And in a sense, then, populists playing with the rule of law or with the judiciary is not an innocent game. It's about an attempt to construct another kind of world. A world in which I wouldn't want to live, actually. And that is what makes it very serious. That accords very well with what Huizinga, on which, let's say, I reflect in the paper, defined as an essence of play. So play is a combination of frivolity and seriousness. But seriousness without frivolity is not play. In the article with Frans Willem Korsten, we define that as asceticism. So we consider Trump to be a political aesthetic. And you can skip the term political. Trump is not a politician. That's a statement for now, but I argue kind of elsewhere why that is the case. So let's go into the article more. And the article works towards the suggestion that especially in the field of the humanities, I think Greta's study is immensely important. Correction, it is important in the field of the humanities, but has enormous implications for other fields. So I come up with, let's say, the suggestion that we should pay attention to what I call playful legalities. So if you think about, let's say, the feelings that people have about either law or justice, you could think about these in terms of somehow, let's say, internal, as if people have these things. They don't. Things are being kind of manipulated constantly or practiced constantly. That's perhaps also a better term. So what I think is important in Greta's study is that the fact that the entire cultural, in a recent interview, I called it a soup, kind of this immensely complex field of all sorts of cultural expressions that all work on our senses of law and of justice, which is an important distinction I make. After this, let's say, presentation, I might get into a serious debate with Jeanne, because I really make a principal distinction between emotion and affect, based on Spinoza, by the way. So that we might have a serious debate, because I think the Anglo-Saxon take on affect is indeed more closely to emotion. But the continental take on affect, which is, let's say, running from Spinoza, if you want, through Marx to Deleuze, is not emotion. It is what is done to us, how we are being affected. And what I think Greta is developing in a very elaborate and intelligent and sensible way is this combination of emotion and affect. You can't have affects. You can have emotions, but you can't have affects, because affects are relations. It's what's being done to us. In that sense, let's say this dynamic between law and justice is so important in relation to this full soup of all sorts of cultural expressions, including, by the way, more and more, the way in which the law shows itself to a general audience, which is no longer simply controlled by, let's say, the judiciary itself. It is part of a very complex, mediatized landscape in which actually no one is in control, and we are all being affected by things that we sometimes even don't understand. So this is why I wanted to go back to Huizinga, who has this famous book, Homo Ludens, also often used in game studies, I think in a wrong way, because for me, the essence of this study is that it was published in 1938. Now, why would you want to publish a study in Dutch in 1938, knowing what's happening in Germany, which is, by the way, also the year of the Kristallnacht? So why would you want to publish a study that says culture finds its origin in play? Well, it's not that difficult to kind of come up with an explanation. His major opponent is Carl Schmitt, who says culture starts seriously and play is an after effect. And counter to that, Huizinga says, no, culture starts as play. And the judiciary starts as play. He doesn't say law starts as play. He says the judiciary starts as play. Which means that he is making an argument against the essentialization of culture, but also the essentialization of law or the judiciary. And I think that's an extremely interesting move. And I'd like to kind of recontextualize Huizinga here by pointing again to the fact that it was published in 1938, also in the context of the resonances in which we find ourselves nowadays with the situation of 1938. So that's why I wanted to go back to Huizinga. And this is a quote that kind of that I found, let's say, at the heart of what I wanted to study. It's in a chapter called in Dutch, Spel en Rechtspraak. And by the way, there's now 2 different kind of groups working on a new translation of Homo Ludens, because it was translated in German, and the German translation is at the basis of the English translation, which, as you may kind of can imagine, causes some conceptual problems. So let's say, this is a chapter called Spel en Rechtspraak in Dutch. It's translated in English as Play and Law. It's the wrong translation. The title means Play and Jurisdiction. So what he's concerned with is not law in itself, but jurisdiction. And there he says, what's the historical origin of jurisdiction? And Huizinga says, it consists in battle, agon. And legally, this battle takes place in a sacred meeting of opposing parties with a judge as an arbiter in a particular space. You could call it the magical circle, with predetermined rules. And let's listen. And good faith adherence to the rules of the game by all the parties. Right. That's another chapter that I've written about this. This is not in this article. And good faith adherence to the rules of the game, because that's another problem in the current circumstances. And then he comes to the core of his argument, and this is the quote. What is at stake in the procedure in front of a judge, in all times and in all circumstances, is the intense, the vehement, the exclusive desire to win, so much so that the moment of agon cannot be eliminated, not for a minute. This is an aside, which is more than an aside. I can have all sorts of arguments against this quote, but I need to kind of include the fact that law, historically, conceptually, architectonically, and practically, has been patriarchal. So at the basis of all this is a pretty male desire to fight one another. Perhaps something for another special issue, but let's say an important issue is, so how can you state, I think it's true, but how can you state what is at stake in the procedure in front of a judge in all times and in all circumstances is the intense, the vehement, the exclusive desire to win. So much so that the moment of agon cannot be eliminated, not for a moment. So, okay, so what does this winning then do? And that's where I distinguish between 3 aspects of the architecture of law that I think Huizinga sees very well, which are 3 things. Throwing the dice or drawing a lot is a game of chance. So first of all is chance. Then, secondly, Huizinga considers how issues of justice have historically been settled through physical contests like battles and fights. So chance and match. And then thirdly and finally, Huizinga discusses the relation between jurisdiction and wager. So this is different from chance. The wager I kind of connect to Pascal in relation to the fascinating figure of Berlusconi. So if Pascal's argument in relation to God is, suppose God does not exist, that's, let's say, for him, a no-go. But suppose, let's say, you don't believe in the existence of God, but God exists. What should you do then? Well, wager that he does exist. And this is the, let's say, the first part of the article where I say Berlusconi, in a sense, doesn't believe that the system of law serves him. He wants to use the system of law, and he wagers on how the system of law will constantly be in his advantage. That's the first part. The second part is about Trump, who, in my reading of things, considers any kind of confrontation with the judiciary as a match. Likewise, he deals with all his opponents, or any opponent or anyone else. One of my favorite questions to people who are not familiar with Trump is, so in how many legal cases do you think Trump or his businesses were involved before he became president? So that's now 8 years ago, before he became president. And then most of my, let's say, partners in conversation say, well, 5, 10, 15, it's a little more, 100, a little more. And if we get to 1,000, they say, no, it's not more than 1,000. So let's a little more. It's 3,500 before he became president. So does he really become nervous because of the fact that he's now kind of brought before court? He doesn't, because that's the game he's been playing for decades. That's what he's doing. And then finally, I moved to the Bolsonaros in Brazil, which is more than the President Bolsonaro, because there's an entire family of Bolsonaro members who are all brought to court. And that's where I deal with the element of chance. So in a sense, what I do in the article is I explore three intrinsic elements of the judiciary, again, judiciary, that are intrinsic to the system and that are played with by these parties that miss any good faith adherence to the rules of the game by the parties concerned. So that's another aspect of what we could discuss. And I've already been talking too much. So let's open up the conversation as far as I'm concerned. Thank you very much.
Thank you, Frans Willem, and thanks to all of our three speakers. We do have sort of met our goal in that we have more than half an hour for questions. So since this entire panel and the special issue really takes Greta's book and research as its kind of reference point, I would like to give Greta first the chance to respond or engage or whatever it is that you would like to say.
First, thank you all for being here. This is a very strong form of love engagement with someone's work, also treating it seriously. And I'm very honored also that by those of you who are here, some of you who are very valued old friends and others whom I don't know. So thank you for being here. I think that a wonderful thing about, and this was the gift that Wibke and Birte gave to me with Simon, which is this special issue, which I look forward to in some way. I'm going to need the haptic object at some point so that I can really know that it exists and not just as text somewhere, is how it no longer belongs to you. It never belonged to you. And so a thing that is very exciting for me also and this is true of Gerlov's work and of Annike's work and of Laura Borchardt's work, is how they are taking concepts like legality and Rechtsgefühle, as I use it, legal affects or legal feelings or feelings for justice and law, and taking it in their own directions. So I'll just give a few responses. First to Gerlov, thank you. I think one thing that was very resonant to me in hearing you speak about your work today is how legality is very contested in what I would call post-migrant Netherlands or post-migrant Germany, where we are all, if you will, migrants, even if we don't see it that way. And there are, as in Germany, forever definitions of are you German or are you migrant, whatever your citizenship status is, based on how people look or their names or their religion. And I think a point that you made in these conflicts is the statement of people are too emotional about things like this statue is a way of one which is traditional in attributions of more emotionality. It's feminizing, it's gendering, it's emotionalizing, taking them outside of the realm of rationality. And it also reminds me of something that Terry Eagleton once said was, when we don't like it, we call what the other person thinks ideology versus politics. And I think that's really resonant for where you're going and taking legality. And I'm just happy about it. Keep running. And you're going to be, I'm going to be seeing how you use this term in development in the future. To my very dear Jeanne, whom we had very recently at her, the honor also, Frans Willem and Gerlov were there of honoring Jeanne's life work in Rotterdam recently and engaging in a not dissimilar way with where we take her work, particularly on empathy and empathetic narrative interpretation in the practice of doing law. I have said of you in the past, you don't suffer fools gladly, and that includes both those who come from the legal profession, who write abstractly about law without practicing it, as well as those who come from other disciplines who theorize but do not practice law. So I guess, and I take your criticism seriously, and what I was pointing to that in the book, thinking about what would you do with this discussion of affect that I was celebrating, and would you not say pragmatically, well, how can I use this in my legal interpretive hermeneutic work? And I guess I would say, I believe that law, whatever people think of as law or lawful, as I have said in the past, is used as a locus of authority. I've read the term lawfare recently, and that this is used in very political ways as a way of drawing on an authoritative instance to argue for something. And what I find very interesting, going back to Jherin's work, which many of us have worked on here, is a sense of where does that come from a legal system or legal environment, and where does it come from some kind of more diffuse but very passionately felt sense of justice, of what's right and of violated rights. And I think I can completely agree with your contention that the role of affect in law is problematic and also genuinely could get in the way of legal proceedings. But I also think I'm describing what is absolutely going on now, whether it is for those who use, in my own country of origins, constitutional symbols to try to pose a coup to take over the capital, or here in Germany, those who held up the equivalent of the German Bill of Rights from our Grundgesetz to say why they shouldn't have to follow restrictions related to health in the Corona period. I also think that you bring up something which is very true. I did do my Spinoza, but it was English translation. And I think there are two big theories of how to interpret Spinoza. Frans Willem has mentioned one. I would say it's Masumi Deleuze, which informs a lot of work going on in continental philosophy right now. Another one in a whole other tradition are the historicization of emotions and group emotions, which I associate with Sarah Ahmed's work. And I'd like to just hold out there. I do see a strong difference between emotion and affect. I won't go into it, but also between individual affect and emotion and group emotion, and the narratives that go along with that. Just to hold out that right now. So I'm not saying that you as a judge need to, say, well, what are your legal feelings in your hermeneutic reading and your applications of norms to cases at hand? I am, however, noting something that I saw very clearly in Frans Willem's more recent work, is how are people also using law or legal proceedings in highly politicizing and polarizing ways. And I guess that is what I would move on to Frans Willem and where I see him going with his work, which is in some ways more, as I read your piece, for instance, for the volume on Rechtsgefühle, which is in some ways less critical of legal institutions than I've seen you in the past, and more a seeing of how are they being manipulated and legal procedure being manipulated in ways that are extremely hurtful for democracy. So that would be a first response, and then I will be quiet for a while.
Thanks, Gerda. Do any of our panelists want to respond at this point before we open up the floor?
I would.
I thought so. Please go ahead.
Well, the point that Greta made about the use of law is very important, I think, because just to give an example, what we see in current Dutch politics after the November election, that the, let us say, right-wing parties wanted to discuss the Dutch constitution, whether or not the new leaders would adhere to the Dutch constitution, which of course, as many constitutions have it, starts with Article 1 on equality. And to jurists, this is absurd, of course. If you have a constitution and you do not go through the motions of changing the constitution in the correct legal and political way, why would such a conversation about adhering to the constitution be necessary at all? So there I agree, and I'm very much inspired by Greta's work and also Frans Willem on how politics try to monopolize law as an instrument to sort of prove that they are right. So that would be my short response. And yes, Frans Willem, I am aware of the delays on etc. But what I wanted to say in my paper was that in the Anglophone world, not many people have a look at all the translations of Spinoza in English. So that's a bit of a trouble. Okay.
Thank you. Maybe then at this point we can open up the floor to general questions. Merely use the raise hand function. I will try to keep an eye on all of you as best I can. I see Birte raised her hand. I don't think we have any other raised hands at the moment, so please shoot.
Hi, so thank you everyone. That was very inspiring, and although I have obviously read the essays many times, I was fascinated to hear you speak about them because we haven't actually had that before, so thank you very much. I want to trace back to Gerlov's essay because I think what came across stronger in the essay, focused on the question of affect and, how, does sort of the relegation of certain arguments to too much emotion, how does that actually repress plurality instead of allowing it? But I want to look a little bit at legality and perhaps also at the law in a more narrow sense, because what I found so interesting is that, the people who tried to move the statue to the museum and to make it sort of, not a celebration of Kuhn, but, to make it point, to start a conversation, they were aligning themselves not with, you could say, like, we don't want this violent person to be celebrated, but they said, we are home, the Netherlands are home to the ICC. And they, put their identity into this strong legal context. And I wonder, are there more contexts that are sort of law or jurisdiction proper, where the affect around the statute comes into play? And I'm thinking in terms of, are there discussions in the Netherlands? And that's really sort of a knowledge question. I'm not sure how many people are, aware of the details of politics in the Netherlands. Is there talk, for instance, about reparations to the Banda people or to anyone in the context of this colonial history, and do then discussions about, sculpture perhaps inform those kinds of discussions or other legal aspects?
Thank you. Thanks, that's a great question. And it is very current because in the Netherlands in the last few years, actually, several important state representatives have officially apologized for the colonial past. Most recently, the king, officially. Before that, the Prime Minister, Mark Rutte, and before that, Femke Halsema, the mayor of at the time, mayor of Amsterdam. And so those are three official apologies in recent years. And of course, these apologies are official, so that means that there is at least some kind of possibility that it will also have consequences in terms of reparations, for example. Although recently I have been in conversation with Wouter Verhaert, the person who, legal philosopher who's responsible for officially advising the king and several other people on the way in which they would frame these apologies. And he wrote really interesting material and told me a lot about how these excuses or these apologies are usually framed in a very strategic way, and it comes very close to repressive tolerance again, kind of an apology that makes it at the same time possible to feel, wow, how nice of the king that he apologizes, and how liberal of the Netherlands and tolerant that they are willing to admit that they were wrong in the past, while at the same time strategically making it really hard to act upon it afterwards in any official sense. So when it comes to, in recent years, and the question is, and it's kind of a speculative question that I certainly cannot answer, to what extent are, for instance, the king effectively inspired to make such apologies in a time like this? To what extent are recent outrages since George Floyd, certainly, but Black Lives Matter protests in general, but also longer ago, since Rhodes Must Fall in the mid-2010s, this was already becoming kind of a global international issue, colonial statues. To what extent did this inspire the king to make these apologies, for example? So to what extent do these effective kind of discussions in society inspire political consequences? I'm not really sure, but it's certainly a fact that Dutch society is currently actively thinking about how to deal with the colonial past. It's also a time in which there's lots of practical discussions about what to do with stolen heritage, for example, museums that own Benin bronzes, for instance, and how to deal with this. In the last few years, several ethnographic problematic museums have, renamed themselves appropriately and kind of like restated their mission statement in such a way that it becomes less a matter of a museum that used to be an anthropological instrument of colonial oppression, but now it looks forward and tries to create a cultural, global happy world. So there's a lot is, I'm not sure if this is an appropriate answer to your question, but there's a lot is currently happening in terms of and discussions about reparation are certainly being held. And it was also recently, I think last year, that actually Indonesia made an official request to have the Koen statue in Hoorn removed, which is for the first time that Indonesia also goes on the record taking offense with the statues still existing in the Netherlands. Meanwhile, I think the last thing I want to say about this, a few months ago, I was at the expert meeting organized by the KNAW, so the Royal Dutch Academic Society, and they gave an advice report about controversial statues in the Netherlands, including the one of Koen in Hoorn, and their official advice based on the newest research on this is that municipalities should work actively towards reframing these statues. So kind of like they try to move beyond the binary question of removal or remaining, like keep the statue or kind of take the statue away, but instead to work towards productive reframings of these statues, and art plays an important role here. So it's kind of like the museum exhibition, but then in a more productive sense and in a more stable kind of constant way. So like I had to have yearly festivals around particular statues, for example, that help commemorate in a more balanced way. Thank you.
Yes, Simon, go ahead.
So thanks again to everyone for doing this. I did just want to mention all of the contributions are available online in the advanced online feature of the journal's site. So I did have a question, or maybe a pair of related questions. I was really struck by the interrelational point that was raised as to the distinction between affect and emotion, that emotion is something that you have, and affects exist between people, so that you can't have an affect yourself. And also the point about the importance of doing the value of empirical research in this context. And I was just wondering if I could invite the speakers to comment more on those aspects. It strikes me that there's often not much use of empirical work in this area, and I thought their urge to incorporate it and take advantage of what's there and think about ways of using it could be very productive. And maybe it might also have some bearing on the argument that affect, because it is interpersonal, might perhaps be something that can be studied in an empirical way.
Who would like to go first? Yeah, please, Frans Willem.
Yeah, that's a tough question, Simon. But there's been research on this. So let's say the latest thing that I'm looking at is the right of victims to speak in court, or their relatives.
Oh my God.
Again, let's say a broader force field, right? So how come, especially in the Netherlands, where in 2005 we get the first, let's say, legal acknowledgement that victims have the right to speak in court, and then in 2015 that kind of right is expanded immensely. So now a victim or a relative of a victim can say anything. Simon can say anything. In the process, in let's say, while the court case has not been decided yet. So let's say as a victim or relative, I can, for instance, address the accused of saying, this is what you did to me, not proven yet. This is what I think you deserve. You're not on the seat of the judge, and so forth, right? So very complicated. And that's where, let's say, official, let's say from the government side, a committee has been, let's say, installed to check how is that going. So they check all these cases, they check what judges are saying, and so forth. So if that's what you mean with empirical research, yes, that's been done there. And then they come up with actually pretty predictable results. But as for the effect, for instance, of populists kind of playing with the rule of law, no, that's not been empirically assessed. But there as well, you could say, why would we need exactly empirical research if there's so much evidence out there in newspapers, in social media, where we see responses to what's happening? Yeah, of course, we can start to measure that in terms of how many people are involved. So let's say that the latest thing that I've been looking at is the case of Alex Jones, who, while he is being sentenced by a judge, at the same time is online commenting on the ruling of the judge. And if you want empirical research, the result is that people rush in to fund him even more, to grant him even more money. So I'm not sure whether empirical research would really be functional in terms of, can we measure how people are affected by this kind of play with the rule of law? Perhaps I'd be more interested in, okay, what's the flow of money? So how many responses are there? It's a good question. And at the same time, I do think that there wouldn't be too many surprises. So let's say the fact that the authority of judges and of the judiciary per se is not rising, but kind of dwindling, or is more and more questioned. I mean, the signs are all over the place. So in a sense, I could ask you back. So why would empirical research be the solution here to something that we can actually all see already happening?
Should we leave that as a rhetorical question? Because I know Greta wants to weigh in, or
Okay.
Simon, do you have a response?
So I would just say very, very briefly, it strikes me that the value of empirical research in this context is that we might certainly have intuitions or hunches based on what appears in print, what appears in social media, but there's always the question of whether that's verified, and also the question of whether empirical research brings out aspects that we hadn't expected. So I feel like it's not simply a question of documenting responses as such, but of trying to understand with more nuance and subtlety what's motivating people's responses and how they're manifesting.
Greta, please, I think you were next on the hand-raising list.
I'd love to hear what Martin has to say, so I'm going to be really brief. I think one of the things about being an amateur in so many disciplines as I am is that you're constantly picking up things, different kinds of flowers and growths and notions along the way. So identifiable victim phenomena has been tested multiply and very numerically is taken as a given. It's also something, however, that seems to have been there for a long time in narratological theory about narrative perspective. And the more we know the detail, what we call realism and realist detail, the more of a sense of sympathetic community we'll have. And so for me, it's often a quest of looking at different disciplines to say how they're looking at the same kind of phenomena.
Martin, please go ahead.
Thank you very much, and thank you for this inspiring discussion. I want to expand on what Simon said. I agree that one should not create opposites where there could be synthesis or could be complementarity. I think that a discourse analysis or more humanistic methods could be complemented, particularly in relating to
Martin, we're losing you. Can you speak more to the camera, please?
Yes, can you hear me better now?
Much better, thanks.
Maybe I should also open this thing here. Is it better now?
Yes, this is much better.
Okay, let's see my new equipment. I think what it is worthwhile also to relate to or to study the legal consciousness debate within the field of sociology of law. It usually is a little bit lacking interest for effectivity, but I think their results and the issues they take on board are instructive for our discussion. Particularly when we want to discuss the dangers of the disembedding of justice from law, which has political consequences, particularly related to populism and social media. I think of course, textual studies and media studies are important, but I think grounding it in other methods or with other methods is helpful. Thank you.
The audio still went sort of in and out of focus, if I can call it that way, but I could hear it well. I think it was better this time. Simon, were you able to follow?
Yeah, no, that was great.
Okay, thank you.
Do we have responses to Martin or any further questions at the moment?
I would only say that Martin was one of many scholars, legal sociologists. He's a legal anthropologist, amongst many other things, who made me aware of legal consciousness and that it has a long European as well as American traditions. And I think thinking about legal subjectivity is a different way of working with the concepts of legality and affect that I'm interested in.
And we'll continue with Birte.
But only if there are no questions from the rest of the audience. So, and this
I don't
is
see
basically
anyone else's hand up, so I think you have the floor.
okay. This is a question for Frans. Just because we're in this current situation, so I was totally convinced by your essay and by the argument that we are sort of flooded by numbers, and that sort of the effect that has on audiences sort of a numbing to the law and to the judiciary. But I wonder, can you still play with criminal trials? Because I assume that these 3,500 trials in Trump's case are civil cases. So, when he has to appear, in April in court for 6 weeks, and there might actually be a criminal conviction, is that still fun and play, or can we hope it's going to be more serious?
Thanks. I don't think that it is ever unserious. The point is, suppose in this case Trump is convicted for something. He's been working with this so many years now that his constituency will consider that to be unjust. And that's the major point. So then he becomes a martyr. So let's say in the article, I kind of suggest at some point, if you have survived 3,500 cases, what do people say? Well, apparently he wasn't that bad. Or they say, apparently he has the capacity to survive so many cases, then he becomes a talisman. So there's something, let's say, in the number of cases and surviving it, even if he is convicted. I'm not going to predict anything, but it might lead to forms of civil war. And that's what he's been doing. So let's say in a sense, in my reading of things, he's aiming for civil war in some sort of form. So either the judiciary is not relevant, in the sense that it is incapable of really sentencing him, because most of the cases have been mediated, right? So he simply pays. But if he is convicted, I wish the United States a lot of strength.
We'll turn to Gerlov, who raised his hand.
Yes, sorry. No, I just wanted to say in response to this question by Birte that actually recently I co-edited a special issue on the construction of villains, kind of villains as narrative constructions in the media, among other things. And there's one article that was one of our contributors actually worked on criminal cases of former Yugoslav kind of leaders who indeed play in this kind of sense. They played with their international tribunal type situation and with the kind of I want to say fame, but it's not the right word. But it's a big platform from which everything that they say or refuse to say, or even the way they look, or kind of look with disdain upon the people that are prosecuting them, can have a big impact on their reputation. So and that's what this article is about. It's called Heroes or Villains. I try to open it meanwhile. Heroes or villains, the Hague convicts and their heroic afterlife in ex-Yugoslav national context. So these are kind of prosecuted criminals who use their court cases, especially as a way to become even more heroic to their own fan groups, to put it that way.
Which I guess would be also confirmed in you know, Trump paraphernalia with the mugshot, etc. That seems to be one of his few sources of income right now. Do we have any other questions, comments? Anyone who wants to address the panel? Jeanne, please go ahead.
Yes, I want to respond to Frans Willem. When we talked about the need for empirical research, first of all, what I meant was more research on the level of psychology, in the sense that how can we measure what affects people and what are the consequences. But the victim impact statement in the Dutch system of criminal law is indeed a very good example of what not to do with affect, in the sense that it is a misconstruction. It denies or fails to acknowledge that the Dutch criminal system is asymmetrical, in the sense that it is a battle, an agon, if one may call it that way, between a citizen who is charged with a crime and the district attorney, who has this whole apparatus behind her to prosecute. And in this sense, giving a voice to the victim is kind of introducing a new figure that actually doesn't work in this asymmetrical relationship. And so, because the focus of criminal law is on the defendant, and as Frans Willem quite rightly pointed out, nowadays victims or the parents of children who were killed, etc., have the right to address the defendant and also discuss the available evidence, etc., which most of the time, if they do not have an advocate with them, leads to well, very unpleasant conversations, because they simply don't know what they are talking about, unless they're talking about the impact that a crime had on their personal lives. So that is the interesting point. If you introduce a specific figure like the victim impact statement into a system that is focused on the defendant, it's very difficult in court for us as judges to sort of monitor what is going on and trying to keep the peace without needing police officers, etc., or become violent oneself. Because that is the arena in which all of this takes place, is a serious one. It's not a battle about who wins, but it's also about how the game or the play is played itself, which will lead in many cases to bad feelings, because people do not honor the idea of innocence until someone is convicted.
It looks like we're exactly at the moment where this was supposed to end. I do not want to overly confirm cultural stereotypes and be the punctual German, so I'll leave it to Simon to decide whether or not we can have another comment by Greta.
Oh, Greta, if you wanted to jump in, please do by all means, and then we'll treat that as the closing bookend. Thank you.
I'm afraid I don't have anything totally enlightening to say. I'm just going to follow up on what Jean said, and I looked fairly carefully at the Weinstein criminal case, and in the American case, after the verdict, you have the victim impact statements and then the sentencing. And what I found is that it has at least an aspect of transitional justice, that these over 100 women who were violated in various ways had a sense of, even if they were not completely happy with the sentence or the verdict, of having been heard. And I think that it's about recognition of the individual, which is, of course, and it occurs through narrative and has a really large effective impact, I would say. And that's all.
Well, thanks again to our hosts. Thanks to everyone for coming, and I'll hope to see you at the next of these episodes. Take care.
Thanks so much, everyone.